Okay. And I just want to welcome everybody. Thank you so much for attending this. We've got Robert Clark here. He's a board member at Upstate Mediation Center, and he's been one of our volunteers for many years, and has just been a great, wonderful friend of the center. And so we're very, very appreciative to have him talking about family law for non-lawyers and lawyers who maybe just don't practice family law. So I'm going to turn it over to him now to get started.
Thank you. Welcome to everyone that's come. It's kind of a free form session today. I've kind of come up with an outline of all the family law related topics that tend to show up at a mediation, and we can go through them one by one. We can hone in particular on problem areas if you have them. Y'all can just tell me in the chat, or feel free to turn off your microphone and speak up during our talk. And then at the end, if you have general questions, we can go over those. So I'm going to share my screen, which will be a little bit easier. Let's see. Right there. Okay. So hopefully everybody can see, it's a Word document. It says major areas of an agreement. So what I try to do when I do an agreement is, just I have a pre-populated form that I use that I put everybody's names in. And let's see, let me pull one up. Like for this one example, where just like number 1 is the parties, 2 is the divorce, paragraph 3 is custody. And I put kind of various options of each one of them in there. So all I have to do is go in and delete what I don't want, and then fine tune whatever the actual agreement is moving toward. So that just kind of helps me on drafting, so I can spend more time talking to them and trying to get down in the particulars of everything. So these are the 12 areas that I kind of came up with, and you can come up with your own and put them in any order you want. That's nothing particular. So I thought we would kind of start out at divorce. As y'all know, you cannot agree to a divorce. So what you can agree to is that the parties will not object to father or mother or husband and wife seeking a divorce on the fault ground of X, Y, or Z. Let me silence that. So, or you can say the parties agree to amend their pleadings and seek the court's approval for a divorce based on 1 year. But some judges are particular. You just can't say we agree to a divorce, because parties cannot agree to a divorce in South Carolina. Custody, I've made this little cheat sheet for upstate mediation a few years ago. I use it all the time in my private guardian cases as well as my private custody cases. And it's really try to just simplify things. People come in on their mediations. Let me figure out how to mute this thing. They've got a lot to say, a lot they want to get off their chest. And, my goal as a mediator is to try to get down to the core issues of why do you want what you want? Why do you want him to have supervised visitation? Why do you want mom to, do X, Y, and Z? Well, if it's about mom's exposing the children to a boyfriend and her priorities aren't in order, or dad's using drugs and shouldn't drive the children. A lot of those things can be handled through specific restraining orders in the agreement and take it out of the realm of talking about custody. So this document that I made, I explained to them that there's 2 worlds of custody, legal and physical, and one really has nothing to do with the other. So legal custody is the authority to make major decisions, and there's 4 areas: education, medical, religion, and extracurricular. The types of legal custody: sole is where unilateral decision making by one parent is had without even really consulting with the other parent. True joint is what the parents had while they were married, if they were married. Neither parent is superior over the other. And of course, they walk into the courtroom on equal footing, equal grounds. A fiction that we use in South Carolina is called joint custody with primary to mom and dad. And then you must, and this is where some people don't do this right, you must spell out who's in charge of the final decision-making authority. So you can put all kinds of language in there, and I'll show you one, for example, major decisions says that there'll be significant communication between the parties, which each party will consider each other's opinions. But if they cannot reach an agreement as to a major decision, the person with primary decision-making authority is the final decision maker. So that language you have to put in there for it to stick. Otherwise, if you say joint custody, primary to mom doesn't mean anything in the eyes of the court order, and it doesn't mean anything in the statute. So be careful. What you're doing is you're giving them true joint custody unless you spell out the terminology that who has the final decision-making authority. And of course, you can split up these areas, these major decision areas. One way we settle things is to say, hey, mom, you've got education and religion. Dad, you've got medical and extracurricular. So those are some negotiating tactics to try to get them to resolve things. The other thing I try to explain to litigants is the difference between major decisions and day-to-day decisions. If you go back to that document I just showed you, you'll see the day-to-day ordinary decisions regarding the children's care and well-being shall be made by the party having physical custody at the time the decision made. So, for example, if mom is a vegan and she has sole custody, doesn't even have to discuss major issues with dad. When the children are with dad during his parenting time, he can give them all the hamburgers and hot dogs he wants because that's a day-to-day decision. What time they go to bed? Do they have to do their homework before they can watch TV? Can they have sugary soft drinks? Do they get punished by a spanking or taking their electronics away? All of those are day-to-day decisions. And I try to emphasize that to litigants because they just don't understand that. And, one parent tends to want to micromanage the other parent. And we have to dispel that belief that they have the ability to do that just because they have sole custody. And that's certainly not the case. Let's see. So the major decisions, I explained to them, usually parents are on the same page for medical decision or for major decisions, especially because they generally are going to rely on other professionals. So for example, education. If the teacher, because of testing or behavior or whatever, recommends that a child should be held back a grade, the parent should discuss it, and make a decision, or the person that has sole custody is going to decide that one way or the other. But I speculate that most parents are going to listen to the professionals and abide by that. One, of course, the area of disagreement would be if they live in different school districts and they're fighting over where the child should go to school. That is a major decision. So if that's the only thing holding them up about agreeing to joint custody, primary, or whatever, you could always hard code things in an order. So the parents could have joint custody, primary to mother. However, the child shall always attend the Spartanburg County School District unless the parties agree otherwise. So even though mom may have the final decision-making authority on holding the child back a grade and et cetera, they can hard code the actual placement of the school. So medical would be like, should my child be on ADD medication? That does not prohibit the parent that doesn't have legal custody from getting emergency care services for the child or something minor for the child. Religion, I rarely hear parties fighting about the decision of religion. And extracurriculars, you don't hear too much argument about that. But again, you can hard code things. If both parents are big into extracurriculars, then why not give both of them the choice of each getting to pick one extracurricular a year or something similar to that. When you talk about physical custody, time is basically how much time each parent spends with the child. It can be anywhere from what they call a standard visitation schedule, alternating holidays, alternating weekends, 4 weeks in the summer, a week-to-week schedule, a 2-2-3 schedule. It could be something creative based on the litigant's work schedules, or the children's extracurricular activities. It could be restrictive if one or both parents have issues such as alcohol, drug dependence, mental health issues, homelessness, financial issues, immoral conduct, any of that kind of stuff. But I find going over this piece of paper with parties before they even really can tell me, get deep into the details of their case, I kind of dispel a lot of their arguments. Because I say, this is all the judge, if you go to court, this is all the judge is going to decide between A, B, and C of legal custody and between A and D on physical custody. And I try to explain judges are reluctant to be extremely creative when it's a controversial litigation. They want somebody in charge, and they want to make it very black and white, which is why a lot of them will default to some sort of standard visitation. And there's several of them out there, just because they're specific in times and pickups and holidays and all of that stuff. It takes out all the he said, she said, and gray areas. And let's see what else. So does anyone have any questions about, so once I go over that, then I try to get into their specifics as to why do you want what you want, and try to handle those through negotiation between the parties of, okay, you're concerned about dad drinking while the children are there. Let's put in a restraining order instead of, the general one says you're not to excessively consume alcohol while the children are in your care. Let's bump that up to the parties are restrained from drinking any alcohol while the children are in their care. So all of those kind of little things, like a babysitting clause, for example, if the complaint is dad always drops them off at his mother's house, he doesn't spend any quality time with them. Okay, let's put a babysitting clause in that says we can, if dad needs a babysitter for longer than 4 hours, you have to give the mother the first right of refusal, or vice versa. That's not to, prevent family visitation and relatives, but if you're using them for a babysitter and the other parent is available, then, I think everyone would prefer the parent being able to take care of the children than a babysitter. Any questions on custody, parenting time, conditions? Number 5 right there, I got conditions on parenting time. And let me see if I can see the chat. Okay, there's no chats. So conditions on parenting time, that's where you can address, like, hey, can dad alcohol test mom if he feels she's intoxicated? Can one parent request hair strand drug tests, once a quarter or something like that? So that's where I kind of put in all the special little provisions about things. Sometimes graduating schedule works in particular cases. Child support and uncovered costs. So child support, as y'all know, we use a calculator. I believe this Traxxer's calculator that we have at Upstate Mediation Center on the laptops. The things that you put into that calculator are the party's income, if health insurance is paid by one party or the other, if there's work-related daycare paid by one party or the other, if either party has any other children that live in the home with them, minor children. So it'd be like stepchildren. Let me see. Let me admit somebody that just got in. I guess they got admitted. Yeah, they're trying to get in. So, and then the calculator is going to tell you, what the if there's any alimony paid or received, and then that'll tell you the number. If you deviate, if the parties agree to deviate from that calculator, you want to notate that in the agreement, that it's a downward deviation due to X, Y, and Z. Negotiate, and you can be as simple as due to negotiation of the parties or whatever. But that becomes important down the road if either party wants to bring a modification action and changing their child support. The court is first going to look at what were the conditions at the time child support was originally set, what are the conditions current day, and have those conditions materially changed? And if they have, then what was the reason for the change? Good reasons or bad reasons, like dad quit his job or things like that. So if you deviate, you need to try to explain why. Of course, you can, our system has now changed from paying support through your local county to being a statewide system. So if you're paying through the court system, it's called the state disbursement unit. You need to put in there that there will be an additional 5% fee so that there's no doubt about that. One way we resolve cases where one parent wants it paid to the court and the other doesn't, to save on the 5%, is negotiate and say, well, look, how about we put a clause in there that says you can pay direct, but if you're ever more than 5 days late, then the receiving parent can file an affidavit and have the court require all future payments be paid through the state disbursement unit along with their fee going forward. That way, no one has to go back to court. No one has to pay for an attorney. It's just done by simply filing that affidavit. The child support calculator report will also tell you the percentage of uncovered medical expenses. So the standard guidelines say that the custodial parent will pay the first $250 per year per child. Then they will split any covered cost pro rata based on their incomes. And if you look on the child support calculator worksheet, it will say down there what those percentages are. Now, you want to be careful about what are uncovered costs. The more you put in there, the more liable they're going to be. So some people just put uncovered medical, dental, and vision. Some people add orthodontia. Some people add mental health services. Some people add any number of things. So you just got to be a little specific as to what is contemplated. You know, is cosmetic surgery contemplated? Such as, you know, if a child had a cleft palate, you know, that's, I would I would consider that medically necessary, but you know, insurance might consider that cosmetic. I don't know. I'm just trying to use that as an example. But you want to be specific on the uncovers if you are including or excluding other things. Any questions so far on child support or uncovereds? No. Equitable division. So a lot of times the major asset of families divorcing are going to be their home, their retirement, and their automobiles. Those typically be the big ticket items. I do it on a worksheet. I actually do it on a program called Settled, but you can do it on a worksheet where you list out, or you can get it off the people's financial declarations where you list out who's getting what. But ultimately, let me back up. Ultimately, the goal of equitable division is to divide it in half, essentially, even if it's a 2-year marriage, because the definition of the marital estate are assets and debts that were incurred during the marriage and exist as of the date of filing. Everything is valued as of the date of filing, except there's some circumstances like maybe retirement accounts that might be going up and down if you're going through a year-long separation that you value at the time of the final. But the goal is to get the values of everything close to the date of filing, add it all up, and then divide it by 2. Once you have that magic number of what each person's supposed to get, you go back up and they cherry pick what they want. If they get the car and there's a loan against the car, they get both. They get the car and the loan. So the loan would be a negative number. The asset of the car would be a positive number. The value of the car, again, would be as of the date of filing. If you were just to sell it on the open market, what would someone pay for it? The market value. So then if everyone goes back and cherry picks what they want, if they get down to the bottom line and it's lopsided, then one parent or one spouse may need to pay off the other spouse to get it to that equalization. Now, again, these are simplistic things. I'm not trying to get into a lawyer's in-depth analysis of financial condition, because there's a whole lot of arguments that can go on as to whether it should be 50-50 or a higher percentage for one parent or the other. The Supreme Court has repeatedly said, we're going to start at a 50-50 division and then go from there based on many factors. Those factors are things such as length of marriage, age of the parties, health of the parties, earnings capacity of the parties, the non-marital assets and debts of the parties. So the fault ground or the fault of the marriage breakup of the parties. So the court can then deviate who earned the money. You know, if there's a stay-home person and the other person was a full-time worker. So the court could deviate, you know, up to 10, 15, 20%, you know, like a 60-40 split. But it's going to be fairly small unless it's just a mega case where the court determines one of them was a gold digger, and, you know, so just be mindful of that. If it's not a complicated case, then shoot for that 50-50 division. Houses, again, seem to always be the problem, because the parties are going to have to determine if one party wants the house and they're both on the deed and mortgage, how are they going to get the other parent's name off? Do they have the ability to refinance the house in their name only? Was there enough equity in the house in order to pay off the other parent to make the division work out? So some of the clauses we put in there is that the parties will put the home up for sale with a licensed realtor. Any necessary repairs made whoever fronts the money for repairs would be repaid first out of the proceeds of the house, and then the net proceeds after repairs would be split 50-50 or whatever it is to the parties. If one parent wants to keep the house, then you can say, if the parent cannot refinance the home within 3, 4, 5, 6 months, then the parties shall put it up for sale and split the proceeds. So the whole point is you want to try to think of language in there that prevents the parties from having to come back to court. You can't always prevent it. Some of them will start fighting over the price of the house. So, you know, if the only thing you're mediating is selling the house and you've got all morning to do that and you're not having to worry about custody and all that, then yeah, y'all can dicker back and forth and say, okay, we're going to take the realtor's recommendation on putting the market value on the house, but if it doesn't sell within 30 days, we agree to drop it by $2,500 a month for the next 4 months, and et cetera, et cetera. You can become as complicated as you want, as the litigants want to do. The other catch-all phrase you can do in there is to say, hey, if the parties need assistance in helping sell the house, they are butting heads and we can't get past this issue, then the parties have leave of court to file a motion for the court to address those issues. So you're not opening up a new case and a new can of worms. You're just going back saying, hey, court, we know we got to sell the house. We can't agree to the sales price. Could you help us out? And then the court's going to do basically what we just talked about, is putting some timelines in there. You want to put a general clause in there going forward that each party is to not incur debt in the name of the other. Retirement accounts. That was the other big one, you know, that a lot of people have. If the retirement account is if the retirement account is an IRA type account, then you do not have to do anything special. The institution will split up that money based on that court order and open it into a new account for the receiving parent. If it is a pension or a 401k type retirement, then those have to be done by qualified domestic relations order, or QDRO for short. Those are more complicated because they have to be very specific to the institution of how they're to split the money up, what happens with passive gains or losses while it's being split up. If it's a pension, how does it work? Because it may be a undefined pension where we don't know what the amount's going to be. It's going to be a percentage. So those are normally drafted by an attorney that specializes in drafting those things. So typically what I do in the agreement is to say, all right, who's going to pay for the QDRO, or who's going to be responsible for getting the QDRO done? So I usually try to make it be the receiver and say, well, I take that back. Usually the person with the retirement is easier to have access to all the information. So make them responsible and say, father shall initiate having or hire someone to do a QDRO within 90 days and cooperate in a timely manner, something like that. So just be careful of those little things because there's additional costs. It could go anywhere from $600 to $1,200 for someone to draft a QDRO order. VA is military pensions and stuff can be a little difficult and peculiar as well. Any questions so far? Anybody want to pop in and ask a question or put in a chat? All right. Alimony. So we've got, let me share my screen again so y'all aren't having to stare at me the whole time. Okay, so alimony. So there's a couple of options. The parties may waive and bar alimony from each other, saying they don't want it, they don't need it. What is the purpose of alimony? Alimony is to help a lesser earning spouse enjoy a similar standard of living that they enjoyed during the marriage. It's not to discourage or prevent the lesser earning spouse from going out and joining the workforce if they're able and maximizing the income that they can earn. So if you've had a stay-home parent that's been out of the workforce for 15 years, but they have a teacher's degree or nursing degree or something that's lapsed, it's going to take them some time to get back in the workforce. That could be something called a rehabilitative alimony, saying, look, we're going to pay for you to alimony long enough for you to get recertified in your occupation, or long enough for you to get a job that will get you up to enjoying that same similar standard of living without retirement. We'll do that for the next 12 months and then it's over. Permanent periodic alimony is until death or remarriage of the parties. So, or remarriage of the receiving party. That is what is preferred by the Supreme Court. Permanent periodic alimony, just rule of thumb, typically doesn't kick in until it's been about a 10-year marriage. The court looks at 17 different factors when determining alimony. And it's those ones I listed for equitable division, similar to those: length of marriage, fault of the breakup of the marriage, education of the parties, historical earning ability, future earning ability, assets and debts outside of the marital property. If there's any children or child support being paid, the mental health, the physical health of the parties. So all of those things can be, and the big one, the need of the party. So, if they both work and they're only $1,500 apart in annual income, it may be hard pressed to show a need for alimony. Another option for alimony is to say, look, there's not a lot of money here, but I'll just give you $10,000 in a lump sum one-time payment of alimony, and then it terminates. That lump sum amount can be paid over time. So don't confuse permanent periodic alimony with a lump sum. So you could say, hey, we're going to give you $10,000 and a lump sum alimony. That's all you get, $10,000. But it will be paid at the rate of $500 a month until the $10,000 is paid in full. Now, something to be very careful of is, can the court modify alimony in the future based on a change of circumstances? The parties have the ability to agree to not allow the court to modify alimony in the future. And it's a simple little sentence. It says, this alimony shall be non-modifiable by the court. And what you're doing is you're taking the power and authority of the court away from the court to where they cannot modify it based on a change of circumstances. Typically, we do not do that unless we feel secure that the parties are going to have sufficient assets to live their life despite what happens. For example, if they become a paraplegic and from a bad car accident. So you need to use that sparingly. And if they don't have attorneys, I'm not sure I would even bring it up at all. Because again, we're not there to give them advice. We're just there to try to accomplish what they want to end up with by an agreement. Alimony, what else on alimony? There's all kinds of rules of thumb for determining what amount the alimony should be. There is no guideline calculator like child support. So, everybody's different. And you really just have to look at the whole picture. Now I could sit here and tell you, hey, take the difference of the parties' incomes and multiply it times 15% or 17.5%, and there's the magic number. But it's really not that simple. That's kind of just getting onto the ball field as a starting point. You have to look at all the factors. And really, as a mediator, what you want to do is turn around and say, what do you really need? Justify it for me of what you need, and based on your historical lifestyle. Name change, that's simple. If the spouse wants to return to their maiden name, you just put in there, the parties agree that spouse may return to the use of her maiden name. Additional terms, miscellaneous clauses, that's where you can get into all kinds of things like just any issues the parties have out of the norm. For example, you want to say, hey, mom shall be the keeper of the children's passports, but shall not unreasonably deny access to the passports by the father for international travel. All parties shall keep each other informed of all travel itineraries and contact information and dates and modes of transportation, et cetera, et cetera. So really, what I try to do is keep all that custody and parenting time simple. And all the related issues that they're mad about or they're concerned about relating to custody and visitation, I try to put down there in those miscellaneous terms and the restraining order terms. Neither party shall talk in a derogatory manner about the other party in front of the children or around the children where they can learn of such, or allow other third parties to say things where the children can hear it or learn of such. So whatever their beef is, try to address it through miscellaneous clauses and restraining orders. And that keeps all that other stuff relatively clean and simple. The stipulations are just some of the generic ones. I believe the MOU, the Memorandum of Understanding template that the center has on the computer now has those in there, but it's like the parties stipulate that they are entering into this agreement freely and voluntarily. They have reviewed each other's financial information and are satisfied with the truthfulness and accuracy of the information. They're not being threatened or harassed. There's no promises outside this written agreement. They want the court to approve the agreement and understand it'll be subject to the contempt powers of the court, which sanctions can include jail, community service, and fines. So basically, if you put all that stuff in there, it's harder for the parties to back out of it and attack it later on.
Robert, we had a
Yes.
question in the chat,
Okay.
from Mandy, about alimony.
Figure out how to get back there. Stop sharing chat. Oops. Okay. How do I see it? Okay. Is it possible that the person who needs to pay alimony has nothing to live on anymore because he needs to pay so much? Is there a limit what the person who pays needs to keep for himself? There is no like magic percentage, unlike child support, that can say, the guidelines say, it can't exceed a certain percentage of the gross income of the party. But that's again where I was saying you've got to look at the big picture. If you've got mom earns nothing and dad earns minimum wage, let's just take that example. My guess is they were living probably a pretty low standard of living. They were not going to Disney World twice a year. They were not, doing other vacations. They were not eating out a lot. So there's probably not a high standard of living to help maintain. Mom, and by the way, if someone is not working and they don't have a work history to base income off of, then the court will impute minimum wage to that person when calculating child support, especially. But they can impute it for alimony purposes too. So yes, I believe the court is going to consider whether or not the paying spouse has the ability to pay. That's a definite issue. And that's why you've got to look at it in conjunction with the payment of child support and see what the big picture is. And can the paying spouse adequately live their standard of living too? It's not to punish anybody. It's just to make sure no one goes on the government doles and welfare and end up on the street like that. Any other questions? I know this kind of went by fast, but I just wanted to, I've got, let's see, just to show you. Yeah, go ahead.
Oh, I was just going to say, is there anything that might cause a judge to not approve an agreement? And I was thinking about, like, with Mandy's question, sometimes I've seen one party feel really guilty and give away a ton for whatever reason. And I always kind of wondered, would the judge approve that if it's so one-sided, even though they agreed to it?
Yes, and that's the purpose of the judge there, is to determine if the agreement is entered into knowingly, freely, and voluntarily, that the people can comply with the agreement, it's fair to everybody, and if there's children, that it's in the best interest of the children. That's what the judge is looking out for. Understanding that there are given circumstances in every case. So, for example, if you've got a dad, Judge Madden did this other day to two attorneys that I heard the story about. They were both pretty high wage earners, but the husband was a very high wage earner. And through very long negotiations of mediation, they settled on a lump sum alimony amount instead of permanent, periodic, ongoing. And the guy was making something like $73,000 a month. I mean, something astronomical. Well, with the equitable division for the wife and the lump sum alimony for the wife, she was walking away with millions. But Judge Madden stood up there and said, ma'am, you realize that by giving up alimony, he's going to be making $73,000 a month and you're only making $20,000 a month. Do you understand that? Yes, sir. You believe that's fair to you? Yes, sir. Okay. Well, if you think it's fair, then I'm going to approve it. But he did question that. Now you can scale that down, take a whole lot of zeros off of all of that and apply it to any normal situation. Especially when one party is unrepresented, the judge is going to be a little more keen on making sure that everything was done above board. And that's why, the more language you can put in an agreement. Again, we're not attorneys to draft bulletproof agreements. That's not our role as a mediator. But when they're pro se, they're probably going to end up using our document. So you want to make it as best you can without crossing the line of being an attorney, if you're not an attorney. Yes, that role is for the judge to make sure that things are fair, but knowing that there is a negotiation. You know, you may have a parent give up alimony and the judge not know that they were cheating. So if someone is committing adultery, that is an absolute bar from receiving alimony. But maybe the parties don't want to bring it up. They don't want their children to find out. But the one parent says, look, I don't want any alimony, but we're not going to say why. So for the judge to question that, you know, some are subtle. And you know, some judges get it and they'll say, Mr. Attorney, it's the reason there's no alimony because there is a bar. And the attorney will say, yes, sir. So that's code speak for they were cheating, they were committing adultery, and it's a bar. So it's not on the table. And judge says, okay, I understand, without actually having to prove adultery. So yeah, good question. Who else? I put up here a statute about joint custody, and you'll see as the statute says, joint custody means both parents have equal rights regarding major decisions. Sole custody means a parent has the rights and responsibilities for major decisions. So those are the only two we have in our statute. So if you write in an agreement, joint custody with primary to mother, what does that mean? It doesn't mean squat according to the Supreme Court. You've got to then comma or period and keep on talking and say, the parties will discuss all major issues together and take into each other's consideration, each other's opinions and considerations. But if they can't reach an agreement, mother is the final decision-making authority. As to religion, father is the final decision-making authority as to medical. So you got to be specific on those things because that's all the statute has is those joint and sole. They also wanted to make clear, because our Supreme Court had disfavored joint custody, thinking if the parties can't agree to joint custody on their own or through mediation after going through the gauntlet of having a guardian ad litem and attorneys and all that, if you go in front of a judge shoving it down your throat is not going to work because y'all can't agree to joint custody, and joint custody means y'all are going to work together. Because if you end up with a final order that says the parties have true joint custody, neither one's superior of the other. Mom lives in Spartanburg, dad lives in Greenville. They have a fight, and I've litigated this just recently. They each want their own school district. What do you do? How do you resolve that problem? Well, the only way you can resolve it, absent flipping a coin and somebody giving in, is go back to court. So that's just causing more litigation. So the Supreme Court said, why would we want to do that? Well, the legislators didn't like it. So they went back and made this statute 63-15-230 that says, hey, the court may award joint custody. And if you don't, you need to tell why. The Supreme Court has said, notwithstanding this new statute, we still have the same opinion. It's got to be some special circumstances in order to award it. And that's always in flux. You're going to get new Supreme Court rulings coming down, and there's always a twist and a turn. And I think there's one right now that may be working its way through the appeal process that I was the guardian on. But another thing you can look at mediation for is to ask to see their parenting plan. If they went to a temporary hearing, they were required to submit a temporary parenting plan, setting forth all of the time and decision-making. If they were pro se, it's probably not going to be done right. If there was an attorney, some attorneys are just say, they don't answer anything other than put, we want Judge Brown's, just being simple about it. But that's one way to go off of to look and see. It's always nice to have the pleadings, the parenting plan, and a temporary order, and importantly, if it's equitable division or child support going on, their financial declarations. And I know y'all probably are frustrated like I am when people, even with attorneys, come to mediation and don't have a financial declaration, or they don't have, or they don't know all the numbers. They know there's some debt out there. I'm like, okay, what's the number? You know, let's put it in the column. Let's add it up. We don't know. Well, how can you mediate? Unless y'all are just saying, you take your debt, and we go our separate ways. So it gets frustrating when they don't come prepared, ready to settle. And, you know, we don't want to make people mad, but the mediators do have the authority to say, y'all going to have to come back because you don't have the proper information for us to do a good faith mediation. Let's see. Karen asked, is there an updated standard other than Judge Brown's? So Judge Brown's is just one of the standards out there. His most recent revision is 2013. The center has that on their computer system. It's on my webpage under resources at greenvillefamilylaw.com. Judge Robertson has one. Judge Alvin Johnson has one, both of whose are very similar. However, they take out a lot of the restraining orders and parental guidelines. There's a movement to say that's just overbearing and it's getting into moral policing by the state or a court system. There is Judge Barry Noble. Let me stop my share. Am I sharing my screen right now? No, I'm not sharing. Judge Noble has a model parenting plan. Now you see how I said keep it simple. You got sole joint with primary two so-and-so, and you got a 2-2-3 schedule, a week-to-week schedule, creative based on work schedules, or restrictive. So I was trying to keep it simple and then put any weird stuff down in additional terms and conditions or restraining orders. This is Judge Noble's that thinks of every scenario under the sun. I mean, it's very in depth. He's done a wonderful job. But if you're a parent, you know, do you want to pull this book out to say, can I feed my child yogurt on Wednesday? And read it. That's can be difficult. And I think people that are using the mediation center aren't looking for that much of a specificity. But the reason this book is so thick is because he gives multiple options for one particular issue. It's very well thought out. But Karen, to answer your questions, there is no official standard. The courts are trying to say you shouldn't call anything standard. Everything should be tailored to the particular case. But when you get into high conflict cases, you know, my standard is I want all of those restraining orders in place. Be careful if you're adopting Judge Brown's. I'm always very specific about adopting, not, you know, like I treat it like two different parts. Section 1 is the visitation parenting time. Section 2 and 3 are the parenting guidelines and restraining orders. It is possible to not adopt the restraining orders and parental guidelines and just adopt the parenting time. Vice versa. If your folks, if the litigants are able to come up with a very creative visitation parenting time schedule, great. Cross out Judge Brown's, but they want all of that certainty on holidays and access to medical records and telephone, reasonable private telephone contact. If you want all that verbiage in there, you can adopt just the guidelines and restraining orders. So you can separate it out. And I have people just go in and just mark 3 things they don't want. Frequently, if parties were never married and they're arguing about custody, we'll go through and strike out section 3E of Judge Brown's about you cannot expose the child to a paramour on an overnight basis. Well, if you're never married to the other parent to begin with, why do you care now? That's just someone imposing their moral and values on somebody else. So, you know, it's whatever. Let the litigants determine their outcome and come to their own conclusion of what they want. You're just assisting them in getting there. What else?
Robert, could you give us kind of like um, a court timeline for how family court cases go through the court without getting too much in the weeds? Because I know there's tons of exceptions and specifics, but just to kind of give an outline of how that would proceed through the court system.
Sure. And I kind of give this little spiel to all of my new clients. Basically, if you want to file let's think of it from the plaintiff's standpoint. So if you want to file an action, you consult with an attorney. You come up with what issues you want to address, whether it be divorce, custody, one of those categories that I put up on that list. We draft the pleadings, we draft affidavits and the financial declaration, anything we're going to need at the temporary hearing. I then, after the litigant, my client, approves all the paperwork, I take it to the courthouse with a motion for temporary relief, and I file it with the clerk's office. They keep the paperwork, send it to docketing. Docketing will call the attorney to set the temporary hearing. That is normally set within 30 days. It's supposed to be. Sometimes they do it a little further, sometimes they do it quicker. Once you have that date and time on the motion for temporary relief and you're clocked and filed summons and complaint, you would get it back from the courthouse, and you must serve it on the defendant at least 5 days in advance of the temporary hearing, not including the date of service. So you might as well call it 6 days. That 6 days is only for temporary relief motions. Otherwise, it's normally 10 days notice time. So once I have the paperwork back, I need to get them served. Hopefully, if they go hire an attorney, the other attorney will call me and say, hey, Robert, what can we work out on a temporary basis? And let's just skip that temporary hearing. If that doesn't happen, then we show up at the temporary hearing, and the judge will read the affidavits and make a temporary ruling. The temporary order is basically rules to play by while the litigation continues until completion. If there is a contest on custody or visitation, the court's going to appoint a guardian ad litem to investigate. Generally order the parties to split the cost of the guardian. Sometimes if the judge is unsure about what's the right thing to do, the judge will ask the guardian to do an expedited investigation and to come back to court in 30 to 45 days and file a report. Then they can alter that temporary order under a second temporary order. If not, then typically you only get one bite at the apple of a temporary hearing, and that's it. So after your temporary hearing and the guardian gets involved, or if there's no guardian, you would turn into a discovery mode. And that's where the attorneys can send discovery to each other, to each side. Discovery can be interrogatories where you ask the other person questions and they must answer under oath. It can be requests to admit. If you're trying to prove that they did adultery, you can ask them to admit that they did it without having to prove it. Because if they deny it and you still prove it, then you're going to get some attorney's fees for them lying and you having to prove it. And it shortens the issues of trial if they admit certain elements of what you're trying to prove. You can do a request for production of documents or things. So you can say, send me your tax returns for the past 3 years. Send me all text messages you've had with your boyfriend, et cetera, et cetera. And then there's depositions. If you want to depose anyone under oath, they would come to your office with a court reporter on hand, and you can ask them questions, and they have to answer under oath. It does not have to necessarily follow the rules of evidence because it's more like a fishing expedition to learn information and follow the rabbit hole. After your discovery is done, the parties and maybe the guardian's done their initial investigation and kind of gives you some feedback. The parties can attempt to try to resolve it through the attorneys. If they can't, then if the parties have sufficient information to try to settle their case, then they can go ahead and do mediation. And again, that's where you hope they come with completed financial declarations, hopefully an interim guardian report, or at least a guardian talking to the mediator to give them a verbal report. So if mediation is unsuccessful, then they use our mediators report to set a final trial. You must have a pending final hearing request form in for a case to remain active beyond 365 days. Otherwise, the case will get dismissed and all temporary orders will be voided ab initio, which means from the beginning, as if they never actually existed. So if you were granted sole custody at the temporary hearing, that goes away and you go back to being true joint custodians. Now the parties always have, there can always be motions throughout that process. So say one party fails to answer your discovery, you can file a motion to compel their answers. You can be awarded attorney's fees. If people are violating the temporary order, you can file a contempt action to force compliance and make them either be sanctioned or pay the attorney's fees for having to bring the contempt action. The guardian, if they see something going wrong, or one parent just tested positive for crack cocaine, the guardian can go in and get the court to order mandatory drug testing or supervised visitation or things like that. So, there's all kinds of motions that can happen throughout the process. So if mediation is not successful, as y'all know, you would talk to both sides to try to determine how long of a trial time they need. You just have to depend on what they say, really. If they're attorneys, then they're going to know pretty well. If they're pro se, you're probably going to have to maybe ask them how many people you think you'll have come testify. A pro se trial, I probably wouldn't set more than a day unless there's unless the guardian says some really extensive witnesses that they're going to need to be called. And what else? If at any time there's an agreement, one of the parties can then request a final 15-minute agreement hearing. And again, depending on how long they're backed up, docketing will normally set that within 30 days. If you have a highly contentious action, and I would only do this with an attorney, the attorney can call docketing and say, hey, I need an emergency slot to get an agreement approved before it falls apart. Because many of the judges have always said, look, you got a contentious one, I'll hear it on my lunch break, bring it in. We try not to abuse that privilege, but sometimes it's needed. What other time frames are there, Jennifer, that discovery requests normally have to be answered within 30 days. Sometimes attorneys will ask for an extension, and as a matter of professional courtesy, the other attorney will say, yes, you can have another 30 days. Certainly we try to get discovery if you're going to do discovery. We don't do discovery in all cases because it's expensive and it's time consuming. But if you're going to do discovery, we try to get it all done prior to mediation so we can make meaningful agreements. I can kind of give you, because I do a lot of private guardian work, I can give you kind of the structure of how I do a guardian case. When I get appointed, I will meet with each parent here in my office individually. Then I'll ask each parent to bring the children in where I can see some interaction, and I will talk to each child individually. Then I check references that the parents have given me that they want me to talk to, and we do that over the telephone and make notes. Then I will get any collateral information that's an issue in the case. So if I need school records, I'll get them. If there's no problems at school, I don't want to bother teachers and administrators. But whether it be school records, medical records, healthcare worker records, mental health records, anything, police records, anything that's an issue in the case, I'll try to get documentation for. After that, that's the bulk of my investigation, and I will do an informal update to the attorneys. Sometimes it's a phone conference call. Sometimes it is a Zoom meeting. Sometimes it's a joint email. And sometimes I just go ahead and produce an interim report, especially if the judge wanted a second temporary hearing or an interim report. That gives the attorneys the opportunity to know where I stand. A lot of times I find guardians keep their opinions too close to their chest for fear of being called biased. Well, my opinion on that is you are biased. You're biased for the children, not one parent or the other. Just because what's best for the children happens to fall on one parent's side and not the other, that's the way the cookie crumbles. But I want to give the attorneys some teeth to either make their case or advise their client in a matter of frankness of where their case is going. If the guardian is accurate, did their job accurately and diligently. So that's kind of the process I do. I don't issue a final report until I know it's set for trial. The statute says you got to provide it 20 days in advance to the final trial date. Let's see, Aaron asks, if the financials of a party change significantly after answers to interrogatories were made, what is their responsibility to update their answers? Discovery is always ongoing. So any new information or changes to information should be provided to the opposing party or attorney timely. At the final hearing, everything should be updated. Like if you have an agreement, your financial declaration should be updated to reflect current day situation as of the date of filing. Especially as to income and expenses. Your assets and debts may be in flux and stuff, but if y'all mediated an agreement and you didn't get in to put the agreement on the record for 4 months, maybe you got a raise or significant bonus or something, you've got to disclose that at the final hearing. And then, there might be an argument over should we recalculate child support based on these numbers, or are we going to honor the agreement and just stick with the old numbers? Can't answer that. That's going to be between the parties to negotiate or the attorneys. But yes, it's everyone's responsibility to update discovery and the financial deck. Let's see, what else? Y'all been so quiet.
That was helpful with the timeline. A lot of times that comes up with pro ses who just, don't know. So I'm glad to have some of that answered. Thank you, Robert.
Sure. Are there any particular problems y'all are seeing in family court mediations that I've just not even addressed at all? Anything y'all run up against or would like to ask about or help your other fellow mediators think about? Sounds like everybody can get everything settled on the first go round. Well, if y'all don't have any questions, I'll let y'all get back to your work day. It's almost Friday.
Well,
Jennifer, can you think of anything else that you want me to talk about or hit up?
I think you answered everything I thought of. As far as guardian ad litems, I guess I would just ask, I know that, every guardian ad litem, it seems like approaches it a little different as far as mediation and whether they attend. Some are very hands-on and want to come and even be in the rooms, and some are just available by phone. I mean, is it your opinion that that's just up to the guardian and where they are on the case, maybe?
I think it is up to the guardians. The last update to the ADR rules, they came out with some language saying about the confidentiality of everything at mediation. And the problem with guardians, or what guardians fear, is if I follow the mediator from room to room and hear things that I'm not supposed to then use as part of my investigation, that puts me in a bind. I don't want to go in there and hear them say, well, look, I really am, cheating, committing adultery, and my kid, is around them all the time, but don't go tell the other side. Well, if that's the first time I've ever heard that, can I put that in my report, or am I restricted due to confidentiality? So I made the decision a long time ago when that came out that I would not attend mediations unless they specifically wanted me there. And if I'm there, I do not go in the rooms with the litigants unless I'm going in to make a statement, but I do not go in and negotiate. Now, the mediator will say, Robert, I need you to help explain how X, Y, and Z works. Could you come in and talk to this side? And I say, sure, I'll come in and talk. I'll explain it. I'll explain my position on it, and then I'll leave the room. But I don't want to hear all their confessions and offers and counter offers because of that confidentiality stuff. And plus, it costs some money for me to be there.
Okay, well, if there are no other questions, I guess we can close out. And I just want to thank you again, Robert. This was so great. And we will
No
put
problem.
this up on the YouTube channel so that our new mediators and those that couldn't join us today, I know anyone who couldn't join us emailed me and said, please make this available. So we will do that.
Yeah, that'd be great. Okay, well, I hope everybody has a good weekend. Thanks for coming.
Thank you so much.
Bye.